Straight ahead on Law and Crime Daily. Former Dallas cop Amber Guyger argues her murder conviction should be overturned in the shooting of her neighbor, Botham Jean.
I acknowledge that she intended to kill because that's what she testified.
And wife killer Scott Peterson inches closer to getting a new hearing in his death penalty case. Plus, real estate heir Robert Durst wants his trial for the murder of his best friend delayed as his attorneys say their client plans to take the stand. And the independent autopsy of Andrew Brown Jr. released by his family. The North Carolina Sheriff's response to calls for release of body cam footage in the fatal shooting by deputies.
Body cameras are shaky and sometimes hard to decipher.
Plus, our investigation continues into the massacre of an Ohio family of 8. The new information prosecutors are revealing as one man agrees to testify against his family over a deadly custody battle.
It just chills you to think about the calculation that goes into something like this.
Law and Crime Daily covering court cases from coast to coast. Welcome everyone to Law and Crime Daily. I'm Brian Buckmire along with Terri Austin. A former Texas police officer is appealing her conviction and sentence for the fatal shooting of her neighbor in his own home. A Dallas jury found Amber Guyger guilty of murdering Botham Jean. Jean was sitting in his apartment when Guyger entered and pulled the trigger, murdering him. She took the stand in her own defense and told the jury she thought she was in her own apartment. Guyger was sentenced to 10 years, and Jean's brother hugged her in an emotional courtroom moment. But Guyger's defense now says the evidence was insufficient to support murder and is asking the Court of Appeals to overturn the murder charge and sentence her to a lesser felony.
How she was able to enter the apartment, how she is able to access an apartment that doesn't belong to her, the problems that Ranger Armstrong discussed that was with the strike plate on the deadbolt. You know, it turns out that Mr. Jean's door wasn't even locked properly.
Mr. Mola, you're overlooking the fact that Ms. Guyger testified that she intentionally shot Mr. Jean.
I'm not overlooking the fact, Your Honor. I agree she did intentionally shoot Mr. Jean because that was her intent. That was the truth. Those were the facts of the case. If she had walked into her apartment and there was an intruder inside her apartment, she would have been entitled to use deadly force in self-defense.
Her defense then went on to argue that if she is guilty, she should only be found guilty of the lesser included negligent homicide.
Intentionally or knowingly killing another human is an evil act. Okay, that's what she was convicted of. The problem is that when she entered what she thought was her own apartment, she did not have evil intent when she entered her own apartment. Merely, again.
Just because of her alleged mistaken belief about where she was doesn't negate her intent to kill.
But Your Honor, it negates, my argument is it negates the mens rea, it negates the evil intent. Okay, because we wouldn't be here talking about this if she had walked into her own apartment. Okay, so she walks into her own apartment and she shoots and kills an intruder. Here she walked into the wrong apartment, and in these horrific set of facts, she shot and killed Mr. Jean. The only difference between those two scenarios is her mistaken belief about where she was. Was that mistaken belief reasonable under the circumstances?
Prosecutors say Guyger murdered Botham Jean and her conviction and sentence should stand.
This is a murder case, not a criminal trespass case. When Amber Guyger shot Botham Jean, she didn't take someone else's property. She took the life of a human being. She took Allison and Bertram's son. She took Brant and Alyssa's brother. She took Alexis Stossel's friend. She took Joshua Brown's neighbor. She didn't make a mistake about that. She knew Botham was a living human being. She pointed a gun at him. She intended to kill him. That's murder. It's not negligent. It's not mistake of fact. It's not justified. Amber Guyger murdered Botham Jean. This court should say so and affirm the trial court's judgment.
One by one, the prosecutors struck down the defendant's arguments, saying Guyger does not have a self-defense claim.
The only evidence of self-defense in this case came from appellant's testimony. She said that she believed Botham was in her apartment, that she commanded him to show his hands and he didn't, and that he quickly moved toward her while saying, "Hey, hey." But the jury can disbelieve any or all of a witness's testimony. And if the jury didn't believe appellant's testimony, then there's no other evidence of self-defense, much less insufficient to reject self-defense. And all the other evidence in the case contradicted appellant's testimony. No one heard her give commands to show hands. Botham didn't have pockets where he could have hidden his hands. The trajectory of the gunshot wound means that he wasn't quickly moving toward her. And no reasonable person would have mistaken Botham's apartment with the red doormat, the backlit room number, the flashing red light on the lock, and the marijuana smell as her own.
Joining us is journalist and true crime analyst Pat Lalama, along with Terri Austin. Pat, Amber Guyger has already served about 18 months. If her appeal is successful, she could be released with what many call time served. What are your thoughts on that?
Well, if we're overturning the conviction and reducing it, or at least reducing that conviction to negligent homicide, that's a 2-year sentence. That's a big difference for a young woman. It's a big difference for anyone. But here's a woman who does not want to be incarcerated. And I think the only thing I would say is, why didn't she ask for backup? Why didn't she administer aid? You know, there's a lot of complexities here, and it's going to be up to that panel to figure it out, but there are still so many questions.
Absolutely. Now, Terri, overturning an appeal is a high hurdle to overcome. Do you see this appeal being successful?
I don't think it's going to be successful, Brian. If you listen to that argument, the judges were really pounding in on Guyger's attorney and asking him multiple questions and saying basically that the conviction of murder was correct. He was trying to argue that the evidence did not support a murder charge. He was stating that it was quite reasonable that she would mistaken his apartment for her apartment, and that many people had done that in the past, and they even had a lawyer who was on the stand who lived in the building. But none of that really makes any difference, because ultimately she was on the stand and she herself said, I intended to kill him. So I think that was very difficult for the jury to overlook, and that does support a murder charge.
Yeah, that testimony from her is going to be very hard to overcome. Absolutely agree. Thank you both. Still ahead on Law and Crime Daily, we'll be coming up. Welcome back. Convicted killer Scott Peterson is one step closer to getting a retrial of his death penalty case. Peterson was found guilty in 2004 for the murder of his wife, Lacey, and unborn son, Connor, in December 2002. He was sentenced to death, but California Supreme Court recently tossed it out and ordered he receive a new penalty phase of his trial. The High Court ruled that potential jurors were excused from the jury pool when they expressed they were opposed to the death penalty. Peterson appeared in court via Zoom on Tuesday, saying few words. His defense is also requesting a new trial for the murder charges, arguing a juror lied during pretrial questioning. He's due back in court in June. Back with us is journalist and true crime analyst Pat Lalama, as well as Terri Austin. Pat, you've been following Peterson's case since the very beginning. Can you tell us a little bit more about the defense's arguments?
Well, today we're doing the power of the appellate attorney, right? I mean, we're really using the full force of what the law allows in these situations. Having said that, I am shocked to be looking at him again after all these years. But his attorney, Pat Harris, really feels that he has a chance for a new trial in that juror number, I'm going to say, allegedly lied when asked about having any police connections or involvements. And the fact was that she had filed harassment documents because of an ex who she felt was putting her life in danger. That's a specific, I mean, that's pretty heavy duty, but at the same time, are they going to decide that everything would have been different based on that one lie? And I think that's where you attorneys know better than me, but I'm stunned. I don't know if there's going to, my guess would be that he's not going to win on that one, but I can't say for sure.
Absolutely. Let's ask Terri. Terri, prosecutors often win these appeals. Do you think that the evidence could outweigh any potential error? I often think of harmless error when it comes to this appeal.
You know, on the penalty portion of the case, Brian, I think that if the judge, in fact, excluded certain jurors because of their view on the death penalty, then we will likely see a new penalty phase. On the trial portion, I don't think we're going to see a new trial because, in fact, even if there were a juror who said that they excluded certain evidence, that was minor, and I don't think it will have an effect on the ultimate outcome of the trial, and I don't think that we'll get a new trial because of that very issue.
I tend to agree, but of course, whether or not there's a new trial or new penalty phase, will definitely keep you up to date on that. Also in California, the murder trial of Robert Durst is set to restart on May 17th, but not without an appeal from his defense team. The New York real estate heir is accused of killing his best friend, Susan Berman, in her Los Angeles home in December 2000. Durst's trial had 3 days of openings and 10 witnesses take the stand before COVID-19 postponed the trial on March 12, 2020. The defense is claiming the 14-month-long adjournment is unreasonable and unprecedented. The appeal went on to cite the 14th Amendment, calling for due process in a jury who has been untainted by a delay in outside influences. The 78-year-old is also suspected of killing his wife, Kathleen, in the 1980s. In 2001, Durst was tried and acquitted of shooting and killing his neighbor, Morris Black, in Texas. He pled guilty to evidence tampering for dismembering Black's body. Terri, at the heart of this appeal is a 14-month delay. What if the jurors say, hey, I was watching Terry Austin or Pat LaLama? Could that be a possible reason for an appeal to win?
Absolutely. I cannot even believe that we've had this 14-month delay. You know, a defendant is entitled under the Constitution to a trial and to a fair and impartial trial. And this is not fair and impartial. As much as I think that the defendant is guilty here, no question about that, in my view, based on what I've seen so far of the evidence, I do think that it is not fair to have a juror sit for that long and expect after this number of months to remember what happened. How are they possibly going to get their recollection refreshed? And is that even fair to the defendant? So I think we could very well get a mistrial here and start all over as it should be done.
Now, Pat, you were there before the pandemic stopped this case, and you're planning on being back there as well with us. What do you think of this potential that Durst could potentially testify?
Well, that is the big carrot they keep dangling in front of us. And they told us in the beginning that he would, and then they walked it back a little bit. And now the feeling is that he will. And I'll be honest with you, because I speak to his attorney, Dick DeGuerin, quite often, and did so today for this show. I think the feeling is, what has he got to lose? I mean, he's not doing well physically. But physically, he's not doing well. And I think his feeling is, what the heck? Why not? You know, what's the worst that can happen? In Durst's own words, he says, I'm either going to die in prison or I'm going to die in some old folks' home. So he sort of has this fatalistic attitude. I will say one thing Dick DeGuerin did, going back to the issue of this jury. He is very concerned about the welfare of the jurors because, as he mentioned, and rightfully so, we've all, as human beings, been changed by COVID. I'm not the same person I was a year ago. And who knows how many of these jurors may have family issues or financial issues or just stress issues. And he wants the ability to talk to all the jurors, and that hasn't been set yet. So I'm sorry for going back to the original comment, but I just wanted to get that in there.
You bring up a lot of great points. Voir dire could be something that they try to do to kind of cure any potential issues, but we'll wait to see how that plays out. Coming up on Law and Crime Daily, one man is pleading guilty to a high... We're back. The family of a North Carolina man killed by deputies say their independent autopsy shows he was shot 5 times, including once at the back near his neck. Andrew Brown Jr. was killed as deputies in Elizabeth City attempted to serve him with an arrest warrant last week. Brown's family says he was shot 4 times in the arm before officers fired the fatal shot near the base of his neck. His family and attorney was able to view a redacted portion of the sheriff's office body cam footage on Monday. The sheriff says he supports a public release of the video.
We also allowed the family of Mr. Brown and his attorney to privately view the video. This tragic incident was quick and over in less than 30 seconds and body cameras are shaky and sometimes hard to decipher. They only tell part of the story. Outside investigators, both from the SBI and from 4 other sheriff's offices, are interviewing witnesses and gathering more information.
Back with us is journalist and true crime analyst Pat Lalama and co-host Terri Austin. Pat, what do you make of releasing only 20 seconds of the body cam video?
Well, you know, there are strong protocols in each department. In fact, this is the root of all the argument about police body cams. And I've gone through it. I've covered all of it in major cities, particularly here in Los Angeles. And the issue is, you know, who has the right to that footage? Do the cops have an obligation to release it immediately? And one thing that a lot of sheriffs and police chiefs have told me is, as this gentleman said, the video doesn't always tell the whole story. And while it creates a lot of emotion and it can be very damning and appropriately so, it can also be exculpatory, and there are also a lot of angles we don't know about. This apparently was shaky and a lot of things were undecipherable. So I think we have to be very careful about how we let a piece of footage define us. At the same time, you can certainly understand.
Absolutely. Now, Terri, it comes to mind because it just happened a week ago. On the heels of a Derek Chauvin conviction where the volume of video was so helpful for the prosecution and finding justice for many people, what do you make of the lack of video being released here?
You know, body cam video is so critical, Brian. We're seeing that even on a national level with the George Floyd Policing Act, it's necessary to see what actually happened. And in all of these other cases, especially in the George Floyd, Derek Chauvin trial, we saw that that video was important. But it's important in all of these cases, whether it's Dante Wright, Adam Toledo, whether it's, you know, Andrew Brown here. We need to see what exactly happened. And I think the fact that the police was hesitant is not a good, you know, position to be in.
Yeah, it's one thing to have the body cam videos, but the question becomes, when you have them, what are you going to do with the video? And we're going to find out how that plays out here. Thank you both. When we come back, an Ohio man turning on his own family as they await trial in the murder of 8 people. Why the prosecutors say there's even more shocking evidence still ahead. Welcome back. We're learning more about the family at the center of Ohio's Pike County massacre and how they operated. Law and Crime's Angenette Levy shows us what other acts prosecutors say support their case for murder.
Jake Wagner pleaded guilty to 23 charges, including 8 counts of aggravated murder in the deaths of his ex-girlfriend and her family. Prosecutors say the Wagners lived an insular life focused on control of children and the young women who entered their lives.
I am guilty, Your Honor.
28-year-old Jake Wagner admitted he and his family plotted and planned for months to murder Hannah Mae Roden and any members of her family who stood in the way of Jake getting sole custody of their daughter.
The defendant has, in essence, confessed and apologized for committing these offenses with his family members and admits to personally causing the death of 5 of the 8 victims.
A notice from prosecutors to introduce other acts evidence claims Jake Wagner assaulted, controlled, chased, and threatened to kill Hannah Roden during their relationship and put her body where it would never be found. Prosecutors make similar claims against the Wagners involving Jake's older brother, George, and his ex-wife and their son. The prosecutor wrote that the Wagners got the woman to sign away almost all of her custody rights under false pretenses and then kept the child from her. The murders in April 2016 were shocking. 8 members of the Roden family shot in the head as they slept in 4 locations. When the Wagners moved to Alaska in 2017, Jake Wagner married a young woman. Court documents say the Wagners threatened to kill the woman and became upset when Jake's daughter started referring to her as mom.
We're fully satisfied that he's gone eyes wide open into this agreement. He knows he's going to die in prison without any judicial release.
Part of the plea agreement for Jake Wagner included taking the death penalty off the table for his mom, his father, and his older brother, George. George Wagner is expected in Pike County Court this week for a motion hearing. For Law and Crime Daily, I'm Angenette Levy.
Thanks, Angenette. Let's bring Pat and Terri in one last time. Pat, kind of sounds like he might be trying to save his family, but as our resident true crime analyst, what do you make of this plea deal, and where should we be looking next in this case?
Well, first of all, what a horrible thing that happened in my home state of Ohio. And it is so hard for me after all the crime I've covered in 42 years to imagine wiping out a couple of families over a custody battle. Among that was emerging among all of these people. I'm not convinced it was just custody. At the same time, it looks like, in his mind, he wants to save his own life, but he also wants to save the lives of his family, yet this will force him to basically rat them out. So I don't know what else to make of it, except it's going to be interesting to watch what happens with this feud.
Absolutely. Terri, do you think we should be expecting more families to start taking pleas for similar deals, or maybe not?
Let's hope not, Brian, because this crime was so heinous. Too many people obviously were killed in one family, and the fact that they don't have the death penalty, that should be enough. I think we should prosecute them to the fullest extent.